Mic ready? In order for them to share online, we need to. Testing, test. Okay, yes, we have two Matts today. Okay, welcome everybody to our probate panel. We have Matt Kelly and Matt Unzicker here to tell you everything you need to know about the real estate probate process. But first, we're going to get started with our sponsor, Cindy Sees. She's going to tell you a little bit about her company.
Thank you. Hi, I'm Cindy. I'm with Third Federal Savings and Loan. If you guys haven't worked with us before, we've been around since 1938. We're based out of Cleveland, Ohio. But what brought us to Florida is because everybody gets out of Ohio during the winter and they come down here. So it kind of works out really nice. So we've been in Florida almost 25 years. And we do bridge loans, we do owner-occupied primary residences, we do equity lines of credit, which is prime minus 0.51 right now. So if you need anything or your clients do, think of us then too. Thank you.
All right, thank you very much to the sponsor, and thank you guys for all coming here. Also, anyone online, thank you very much. I do invite you guys to raise your hand if you have questions. We're going to be going over a few points about probate. So anytime you have a question, we'll have a little segment where we can address that. So as already introduced here, we have Matt Kelly, and he is the of-counsel attorney with Essenson Law Firm, and he's also a partner with American Legacy Wealth Management. And also joining us is Matthew Unzicker, and he's an estate planning and probate attorney at Berlin, Patten, Ebling. My name is Maciej Zaremba. I'm with Fathom Realty, and I've been an agent for about 20 years or so. And Matt Kelly and I are on the Realtor Attorney Joint Committee. So, Matt, you want to just say a quick word about yourself?
Sure, thanks. Maciej, as he said, I'm with the Essenson Law Firm. I'm an of-counsel attorney there. I worked with the firm for 10 years. We did civil litigation, trust and estate administration, trust and estate litigation, all that. I'm also a partner with American Legacy Wealth Management. So I'm here to hopefully address any questions you may have about the probate trust process. Give it to Matt.
So if you just fire off the name Matt, one of us will get the questions answered, but I think he's going to refer to me as Matthew either way. I was born and raised in Manatee County, so it's awesome to see this area grow. I've only been practicing in estate planning and probate trust administration, so this is my, I guess, my area of expertise here, and excited to address all of your questions and teach you guys about the wonderful world of probate.
Thank you, guys. So we're going to start off talking about transactions using power of attorneys, and of course, we are realtors here in this room, so we're going to try to talk about this not from the law perspective as much as what do realtors need to watch out for. And I'm sure you'll have plenty of questions. So let's just start with that. When it comes to using a power of attorney, where do we start?
So the first thing you want to look at with any real estate transaction is who is on the title. And once you figure that out, if the person who's on title is unable to close the transaction for whatever reason, sign documents, the first thing you should be asking is, do they have a power of attorney? The power of attorney would name who is the person that can act on behalf of the title holder. And the power of attorney also, if drafted properly, would allow them to be able to close on your standard real estate transaction, whether that's residential or commercial.
I'll jump in on that. So what you're looking for is a durable power of attorney. If it's the case, because sometimes where you may see these, somebody might be incapacitated, they're unable to sign documents. If it's a durable power of attorney, that kind of survives that incapacity. And I think that the best way to think of a power of attorney is this, and it's different from probate or trust. The power of attorney acts as sort of an extension of the authority of the principal. So the agent can only do things that the principal could do. And so that authority is derived from the principal. So with a typical historically power of attorney, that would terminate if they were incapacitated. Because again, it's their authority is extending from the principal. With a durable power of attorney, it does not. So that's most likely what you would see, because I would say that's typically the kind of situations that you would see it in. And then that agent would be signing on behalf of the principal.
Now, I already have a question for you. A personal friend of mine, I recently found out, is kind of losing it. at a younger age, and she refuses to get, someone to sign off that she's incapacitated. If us as realtors are dealing with maybe a family member that is going to need to list and go, or a friend or somebody, who makes that decision that someone is incapacitated, and what do we need to prepare ourselves with in terms of documentation to, make sure we're safe?
Yeah, I mean, I guess it's kind of dealing with two different issues there, because a power of attorney, like I said, that's a voluntary grant of authority by the principal to the agent. So if you have somebody who's not willing to sign that, you can't force them to. That you're kind of getting into a guardianship scenario. If somebody lacks capacity, they can't make decisions, they're mentally incompetent, they would have to go through a guardianship. Somebody would have to petition the court that they're incapacitated. A court would make that determination. Doctors review them. There's a whole procedure involved, and then a guardian would be appointed. They would have authority to sign real estate documents too, but that's kind of a different issue than power of attorney, where again, that's a voluntary mechanism. You can't compel a power of attorney for somebody. So I hope that answers that.
Yeah, and to expand on that, in the durable power of attorney, when we advise clients on getting those documents executed, it is valid as of the date that you sign it, and it carries through your incapacity. So put differently, when you sign that, you are giving your agent the ability to act on your behalf, even if you are fully capable of signing on your own. That's why we tell clients that it's a very powerful document. There are some states that offer what's called a springing power of attorney, where the powers spring into effect upon that person's incapacity. Florida doesn't have that anymore. We have the durable power of attorney, which says it's effective as of the date that you execute it, and it carries through the principal's incapacity. There are a couple of different ways to determine incapacity without involving the court, which is by your primary care physician and maybe a second opinion certifying that the patient is unable to manage their own affairs. But without them having executed a power of attorney, exactly what Matt said, you cannot force somebody to do that without involving the court, and the court would step in and say, person is unable to manage their own affairs anymore, and so we need to appoint a guardian to manage their affairs and deal with things like real estate transactions.
I'm going to jump in also on that, and a key distinction to kind of help you understand. And like Maciej said, the way we kind of want to do this, if anybody has questions at all, because we're going to be covering a few different things while we're moving along, feel free to, raise your hand, because the point is to try to make you understand this stuff, try to help you with that. So if you have a question, we're happy to answer it. But like I was kind of saying before, so if you think about incapacity and guardianship versus power of attorney, when I said before that the authority of the agent in a power of attorney kind of emanates from the principal, that's not the same with guardianship or incapacity. See, in a guardianship context with somebody who's incapacitated, they actually lose the right to execute a document on their own behalf, and only the guardian can do it. Whereas in a power of attorney, technically both still can, because the principal has not given up authority. They've just authorized somebody to do it on their behalf. So there's a key distinction there in those two things.
So prior to signing a listing agreement that is, driven with the power of attorney, what documents do we need to have to make sure we're okay? And should we have them reviewed? What steps should the realtors take?
Well, as a realtor, you don't have the burden of trying to determine whether or not your client, whether that's buyer or seller, is able to sign documents. We're also not doctors as lawyers. So you don't have that burden of deciding, is this person really capable of signing or not? If there are questions about it, like if you're approached by a family member or friend or loved one saying, so-and-so is looking to sell their property or buy property and I am their power of attorney, you should be ringing bells and saying we might need to involve an attorney to make sure that, number one, the document is valid and they do have the powers to act under that particular document. But just off the jump, you guys don't have a burden to decide whether or not somebody is capable of signing documents. But that.
When you go to closing, all right, go ahead.
No, yeah.
And when we, as realtors, when do we start to engage the person to sell their property? That's the whole idea, is where we're trying to help the executor or the decedent, right? So where do we come into play here, and what time should we start to engage them because sometimes these things could take years, months, or whatever. And there's different ways to get through it. If we have a court order, then we can go to the judge and say, you know, how do we get this released so we can sell this property to maybe get some money in the family pocket?
So there's a couple of different issues there. And, you know, if I understand the questions, let's say you have somebody with a power of attorney, right? The principal dies. That power of attorney is no longer applicable. It's gone. Because again, the authority is coming from the principal. Principal's dead, no more authority. It's just a piece of paper. That becomes an estate issue, which we're going to get to a little bit more later. But that's the personal representative who we need to do. So the person who died, the decedent who owned the home, they're gone. They're out of the picture. It's now an estate asset, and that's a whole different procedure. And there's kind of some wrinkles to that on who your client might be, whether that's the personal representative. It may be the beneficiaries. It may just be them and go directly to them. But we'll cover that a little bit more later. Yep.
That's the topic we're on now, is before the person dies, you might see in a lot of real estate transactions, people, and part of this is estate planning, is unable to sign on their own, whether they're out of the country or they're incapacitated. So we thought it was appropriate to start with the power of attorney conversation. We'll work our way to what happens when they ultimately pass away. I saw a hand up. Well, ultimately, when you go through a real estate transaction, hopefully you're using a title company and potentially a law firm, that the burden would eventually fall on them. I mean, if you know, you have you don't want to sign an agreement with somebody that you clearly don't think has the ability to do that. I'm just saying you don't have a legal burden to make that determination. But you know, you can use your professional discretion if you make that decision.
And just before we move on, I just, what I'll do is, as we have a question, I'll repeat it so that everyone online can hear that, since no one else has microphones here. And right now we are talking about the pre-probate section, as it was mentioned. You might have not have heard online, where we're talking about, you know, power of attorneys as one of the mechanisms prior to somebody passing away here. So you're saying that we don't have the burden to assess the documentation, but it seems like we should have common sense to take the steps to get some of these documents. Should we, you know, just as a best practice, should we, at the time of signing that listing agreement, request a copy of the POA so that all this could be reviewed by an attorney? I find, you know, maybe it wasn't properly executed. Maybe, you know, there might be an issue with it, and we're not to make a decision here.
I think what Matt was saying is you're not going to determine that. I mean, you're not going to determine whether it was properly executed. You're not going to determine whether there was a subsequently executed power of attorney, which, you know, nullified the old one. You're not going to be able to determine that stuff. Now, you want to know who you're dealing with, obviously, from a practical standpoint, because what you don't want to do is waste your time. You know, so asking this person, okay, you know, what is your authority to list this property? May I see a copy of your power of attorney? You can certainly do that. And I think, you know, I'd encourage you to do that. They're going to need it for the closing anyway. So you might as well have them prepared, you know, to have that documentation ready, because they're going to have to establish that they have the authority. And that applies across the board. So that's with all the issues we're going to talk about today. They're going to have to establish their authority in order to close a transaction, whether that's an estate, a trust, a corporation, or a power of attorney. So I think it would be a best practice to vet a little bit, you know, that you're dealing with who you're supposed to be dealing with, but ultimately you're not going to make a legal conclusion as to whether or not that document's effective. Saying.
And one last clarifying point is, if the person who's on title saying, I'm selling my property, you don't need to ask them if they have a power of attorney. If somebody's saying, I'm using power of attorney for mom, dad, or the other, then it might be appropriate for you to take a copy of that and have it in your file when you're signing a listing agreement with somebody who's signing under a power of attorney. But I think, and I agree with him, if somebody is trying to sell their own property, you don't need to ask if they have a power of attorney and having somebody else sign for them. I don't think that would be the best approach.
Yeah, and one last question about this before we move on is, can a power of attorney be implemented in the middle of the process? You know, maybe after a listing, maybe after a contract, maybe just for closing documents due to traveling or whatever it may be. Can that be done?
Yeah, I mean, again, it's, it's up to the principal with the power of attorney. So let's say principal signs the listing agreement, you sell the property, they get under contract. There would be nothing that would stop them at that point from having a power of attorney and closing the transaction. It would just have to be documented, again, where this authority is coming from. And that's going to be the power of attorney. So I'd say, yeah.
Okay.
See a hand up?
Where children have power of attorney. Mom or dad are kind of not too sure what they want to do. Kids think that the parents should sell the house and go off to some sort of retirement home. Or can you speak to that situation some? Because I think it's probably fairly common that it happens. People aren't sure what's supposed to happen.
The question was, if somebody has a power of attorney and the principal and agent might disagree as to what is to happen with real property in a transaction, how is that dealt with?
Yeah. So like I mentioned before, I did a lot of litigation. This is like what you call, I guess, a hornet's nest. You see this a lot. It's not that uncommon, unfortunately. But the principal's authority is always going to prevail in a power of attorney situation because, again, it's coming from the authority comes from the principal. They can withdraw that power of attorney at any. They could do it whenever they want. They could name somebody else. I've seen this a handful of times. You'll have one child named a power of attorney, then the other one comes in the picture. They'll do another one naming that child, and I've seen it go back and forth like that. So I guess from a practical standpoint for realtors, number one, you'd have to question whether that's a situation that you want to get involved with. Because again, yeah.
Seems to me.
It is, yeah. Right. Yeah. The agent would have, as long as they have the power of attorney, they have the authority. But the principal, the parent in this example. The power of attorney gives the agent the power to act on behalf of the principal within the scope of the power of attorney, which is an important point because you got to make sure that with the durable power of attorney or power of attorney that you're dealing with, that real estate transactions is one of the authorities that's granted under it because you can have one where it's not. But if that is a delegated authority, then they have the authority to do that, even if the principal is not, the parent is not totally enthused about it. But again, that could go sideways real fast. And I've seen it. And so you'd want to be careful in that situation.
That's why drafting attorneys advise clients, it is a very powerful document. So the person that you name or persons that you name, you should trust because they step into your shoes for all of your finances and property as long as the document allows that. So unfortunately, you cannot write out human nature, but you just need to be informed when you're executing estate planning documents like a power of attorney.
Correct.
And if they do something that's not for the benefit of the principal, there are rules under Florida law that you're not allowed to violate. Like you can't act and take the money and run off to Tahiti with it. There are rules that prevent that, and that's what litigation attorneys handle all the time. Unfortunately, abuse of power of attorney is very common here in Florida. So that situation does arise.
And one other thing is that we keep talking about, durable power of attorney but there's also specific power of attorney, if I'm correct, where you can designate a person to do one particular task only. Let's just say sign the closing docs or execute, the listing agreement while you're away on a trip and not able to sign in the country or something like that. Is that correct?
Yeah, that's right.
Yeah.
Yeah, I was going to say, yep. We talked about if the document allows it. So that's why you have an attorney or title company reviewing those types of things, because just because somebody has a power of attorney doesn't mean that they're able to act in a specific transaction unless the document allows it. So that's also an important thing to review. And truthfully, again, that wouldn't fall on you as the realtors to pick on that.
Okay, well, I'd say, one last question. Go ahead.
when probate will be one of the topics. Avoiding probate is definitely going to be something we address in the panel.
It has nothing to do. So yes.
So our next little section, I think is going to be a short one, is just about property owned in entities such as corporations or LLCs. And, you know, does the entity have an operating agreement or their bylaws? Can you just touch on that?
Similar to a power of attorney, you want to know who has the authority to sign documents related to a real estate transaction. And if the property is owned by an entity like a corporation or an LLC, you would want to know who has the authority to sign on behalf of that. And so that if you see an LLC or a corporation on the title, it might very well be appropriate to ask for the operating agreement because you're signing a listing agreement and potentially a contract with the person who has the authority to execute those. So that would certainly be appropriate for you to ask at the front end. You know, do you have an operating agreement? Can I see it? So you know that you're signing the listing agreement and potentially other documents with the appropriate person or persons, plural.
Yeah, and you know, like I kind of mentioned before, I think a thing to remember is because fraud does happen, and the last thing you want to do is waste your time. And so doing some of this stuff on the front end, although maybe not required of you, I think is a good practice for you to protect yourself, your time, and to make sure that you're, you know, using it wisely and trying to do, you know, you're trying to make money. You don't want to waste, you know, run around in circles and in a situation where, you know, a person doesn't ultimately have authority to list a property, or there's a dispute with a power of attorney or something. So you can request some of that up front, make sure you're dealing with who you're supposed to be dealing with, and then move forward confidently.
Yeah, and one thing I'll touch on that is that I read an article not long ago that there's a large scam in Florida with vacant land that's been owned for a long time by the same person, therefore having lots of equity, usually just residential lots, you know, $30,000 or something like that, where people call agents, claim they're out of town, and, you know, get everything signed and done, and next thing you know, title gets transferred to the new buyer, and then creates a mess, right? Money's gone and it creates a mess. So I would think that that especially in those scenarios, vacant land where you're not meeting the person face to face, checking some of these documents is an extra step that would be worth taking, although not required.
Absolutely.
Okay, anything else about LLCs, corporations that you can think of?
Do you have any questions on that?
All right. Let's go on to property held in a trust. What questions should we be asking?
Well, so you're probably going to be sensing a theme here, but you want to make sure that the trustee is the person with the authority to deal with the property. That's going to be governed by the trust itself. And so two things that you're looking for in that is, number one, that there is a trust agreement naming that person as the trustee, and number two, that the trust gives them authority to buy and sell real estate. Or, you know, you check the title and see if it's owned by the trust. If it's in the name of the trust, then you're going to want to make sure that there's a trustee. That trustee is the person they're supposed to be. Yes.
If I recall correctly as well, this trust documents can sometimes be quite extensive. You don't need the whole document in order to verify. What would we be looking for if they're presenting us with the trust document so we can see they have the authority?
When most drafting attorneys who prepare trust, we also prepare what's called a certification of trust or certificate of trust. Think of it as the snapshot of the important provisions, which would include the names of the trustees and potential successor trustees, which are the backups, as well as including specific powers like real estate powers. So you can rely on a certification of trust for that information.
Yes.
The trust and the trustees only have authority over trust assets. And so if the asset is not, sorry, her question was, if you own property in your individual name but have a trust, how does that work in a real estate transaction? And the answer is the person who's on the title in their individual name, that would be the person that would be handling the real estate transaction, not the trust or the trustee. So after this trust little segment, we are going to get to probate, and that falls in the probate context. She asked what happens if the individual passes away.
So there is to kind of expand on the question a little bit. So I think what Matt's saying is just because somebody has a trust doesn't necessarily mean all their assets are in that trust. And so you're looking at the title, you're looking at the deed to see who owns it. If it's just that person's name, that is not going to be a trust asset. It would say, you know, the so-and-so trust agreement dated something. And then in that context, the trustee and oftentimes that may be the same person. The settlor, the person who created the trust, will oftentimes be the primary trustee. When they die, a successor trustee would take over, and they would be the trustee for that trust. So again, that's all laid out in the trust document itself. So,
He's on the deed, all of a sudden, there's another trust that shows up. And it's dated after the previous one, it changes the first one. How do we know that didn't happen? What would be correct?
well, I mean, I don't know that that's something that you would be able to. Yeah, and that happens. I mean, that can happen. You know, when they go to close, though, there'll be an affidavit or a certification that that person is the trustee of the trust, that they have authority to do this, and that that's the most recent trust. You are entitled to rely on those representations. There's really not much. These things are not recorded publicly, so there's not a place you can go and check. But you're able to rely on that. Yeah.
For those of you on Zoom, the question was if you rely on a trust document and perhaps for circumstances there was another document executed that changed who had the authority to sign on behalf of the trust. You as realtors, if you reasonably rely on that and in good faith rely on the prior version, you don't create liability for yourself. The person who's making the representations that they're the trustee, there's the one who's potentially going to be liable or acting under a document that they have no authority to act under. So that was his question. Yes.
Or it doesn't appear that I just click a button, go to the tax record. Sometimes it can be in an individual's name. However, it turns out it actually is in the trust. It just was not reflected in the deed. That does happen.
Yeah, and that's a good question. And so this is like a best practices issue that I've talked to realtors about before. Don't rely on the tax records. Go to the deed. You can there's a link to it on the property appraiser's website. You can see the most recent deed. Go to that actual document and look at that document, because sometimes it is different. And you want to make sure you're dealing with the right person.
Yep. Property appraiser records are routinely inaccurate.
So don't rely on it.
Any other questions? All right. So we have to rely on the documents that we have most readily available to us. We're not obligated to collect these trust documents in terms of listing. Any other best practices you could think of when it comes to dealing with a trust to limit our liability as realtors prior to marketing the property?
If there are co-trustees, meaning more than one trustee, I always just be aware of procedurally getting more than one person to sign real estate documents can be a little bit more hoops to jump through. So just being aware that it might be just a little more time consuming, a little more coordination on your part as the realtor. If you're dealing with co-trustees versus singular trustees, unfortunately, you're not going to be able to circumvent that unless the trust allows one trustee to sign on behalf of the trust. But knowing on the front end, if you're dealing with co-trustees, multiple people, just know that you're going to have a little bit more procedurally to deal with having multiple people sign documents. So hand first.
Sorry, I just kind of something that I have found incredibly useful, and this is totally from the real estate perspective. your boundaries. Know your boundaries, because I've had situations where their siblings and they're calling up and they're harassing me, but they're not the ones with the authority. And so just to know your boundaries and who you can, who is it reasonable to speak with? So.
Yeah, it's a great piece of advice, and for everyone online. She mentioned that, know your boundaries with who you're talking to. Sometimes there might be 4 siblings and one has the authority in the trust. And the three others are the ones calling you and harassing you to just, stand your ground and I guess relay that info. Yeah. Yeah, exactly. Stop talking.
That's an important point, really, because you'll see that a lot too. I think if you work with trusts a lot, you deal with people who are selling property through a trust, and the settler is deceased, and you're dealing with the children, they're going to act like that's their place every time. I guarantee it. And you're dealing with the trustee, even if it is ultimately theirs, they're beneficiaries, and you may think, well, it's going to go to them. That's how they look at it, but it's not. It's the trustee. The trust owns the property. The trustee acts for the trust, and that's it. And so, that's a really good best practice. And I think it also helps you limit divulging information to people who really, you shouldn't be talking to about it. That's up to the trustee to keep them informed. That's not your job. So make sure you're dealing with the right person.
They're interchangeable terms. She asked what the difference is between a trustee and a trust administrator. They're interchangeable terms unless, and I'll give you the lawyer answer, unless the trust document defines them as something different. You can, just like a power of attorney, you can limit a role within a trust document. So you can name a specific trust administrator for just dealing with real property within a trust, but the trustee has has authority over stocks, bonds, and other assets. So you can have that distinction, but for the most part, a trust administrator and a trustee are one and the same.
And just curious, can the trust designate specific agents to be used to list the property, or the properties?
I mean, I'm trying to think if I've seen that. But
I've drafted that.
Yeah.
I have a very good family friend is a realtor, and they wanted their property to be listed specifically with that realtor. They even set the commission fee within the trust document for that. That's just what they wanted to do. So you can absolutely do that. That's a great thing about a trust, is it gives you that flexibility, but also that control to designate those types of terms within your document.
Now, I personally have a situation on an upcoming listing where one of the trustees or one of the owners of the trust is about to pass away. We haven't gone live, but we've signed all documents. When someone passes, whether it's this scenario or something different, within the documents people named pass, what should we as agents be aware of? Is it just about handing it off to the attorney, let him decide and decipher this, or is there something we can do preemptively?
Well, so it goes to the successor trustee if the trustee passes away of a trust. The trust itself here is the entity. That's the person. The trustee acts on behalf of that entity. So that entity is still bound by the things that the prior trustee may have done. And so the successor trustee would be the person now you're dealing with, but you're dealing with the same entity. That has not changed. And so the contracts that were signed, all that, that's still effective. And it still binds the trust.
Okay.
I've seen some real estate transactions where they did an amendment to change it to the successor trustee. I've seen plenty of real estate transactions where they just left it the way it was, because he's correct. The trust is the ultimate entity that you're dealing with, and the person who's signing it may change, but ultimately it's the entity, the trust, that's dealing with the property. And so if you say, do we have to get an addendum done? That's really dependent on the closing, whoever's handling the closing, but you don't have to in every situation.
Well, you know, so, I mean, did you say spouses? Okay. So from a legal perspective, if it's tenants by the entirety, which they're spouses, then the one half goes automatically to the other. There's no probate there. It's automatic. So now from a practical standpoint, okay, that may be required, but that person, the surviving spouse is the sole owner of the property. Now there might be, they might want you to get addenda to change the contract and change all that, but it's not, that would be the extent of what would be required.
And a death certificate is the thing you have to wait for. Other than that, and you might, and right now they're backed up, so I don't even know 2 weeks from now if you'd have a death certificate, but that really is the only document you need to wait for is the official death certificate. I'll give you the lawyer answer. Say it depends on how it's titled. Most spouses have it tenants by the entirety, which means it just passes to the survivor. I have seen spouses own property as tenants in common, which is an undivided 50-50 interest. So how it's titled is very important. And unfortunately, if it's not in the husband and wife context, it's 50-50. It may require the probate administration to clear the deceased spouse's 50% interest. So how it's titled is very important. And you will need the death certificate one way or the other. That does not change. It depends, because you can also, as non-spouses, Matt and I could own property as joint tenants with rights of survivorship, which effectively works the same as as husband and wife. If one of us passed, it passes to the joint surviving tenant. So that does not require probate. The only one that would is a tenants in common situation. You would look at the prior deed.
So it'll get frustrating because a lot of answers to a lot of questions to attorneys, as you may know, is it depends. And that frustrates a lot of people, but it does. And, with that one, yeah, you look at the deed, you see there's key language that you would see. Let's say it were two unmarried individuals, it would say as joint tenants, and then the key terminology is with rights of survivorship. If it says with rights of survivorship, one person dies, that other half, whatever, goes to that person automatically outside of probate, in which case you would just need a death certificate. If it doesn't say that, let's say it says Matt and Matt, that's it. That's it. Then the half of that person who died would have to be probated. Which would be a lot more.
Which we'll get to in a few minutes.
Yeah.
All right, well, perfect. Now we're getting on to the actual meat of the conversation, probate estate. Where do we start with probates?
The first question that lawyers always ask is, did the person have a will? And I guess I jumped ahead. So probate is required when a person passes away with an asset in their individual name. So anything that is jointly owned with rights of survivorship, jointly owned with a spouse, that does not require probate. Also, and this is actually applies to real estate as well, is assets that have beneficiary designations do not go to probate. They pass to the beneficiary. And the reason that applies in probate is because you may see when you look at a deed called a ladybird deed or enhanced life estate deed. That is an effective way to beneficiary designate real property here in Florida, where you name remaindermen on the deed. So looking at the deed is very important. If the person died, their sole name with no joint owner, no remainder interest or anything like that, that is when we fall into the probate category. And the first question we always ask is, did they have a will? And I'll let Matt pass it off from here when we'll kind of talk about heirs and things like that. So
if you're dealing with property in an estate, again, we go back to authority. I mean, that's always going to be the critical question. And if you're dealing with property and the owner died, it's going to be the personal representative who initiates the estate and would have the authority to sign a listing agreement, sell a property, unless it's homestead property and it's devised to the lineal descendants, meaning they're, let's say, children, for easy example. In that case, it's not a probate asset. It passes similar to a transfer on death account or anything else may be. It goes directly to the lineal descendants, the children, automatically. So there's a procedure to it that happens in the probate estate. But it technically, it never is part of the probate estate. And what's great about that is it passes not subject to creditor claims, which is really, I mean, that's key. That's the big benefit of that is, you can have an estate. I mean, saw this all the time. I mean, you could have an estate with no assets in it other than the real property that the person lived in as their primary residence. And they have creditors, they've got medical bills, they've got whatever else there may be. That house is going to, if it's devised to the children, it's going to the children free of any creditor claims.
With exception to mortgages and taxes, because those are tied to the property. But outside creditors, as you mentioned, medical bills, credit cards, those cannot attach to the primary residence. That's correct. That's correct. Yep. And some people ask, you can only have one primary residence, so it only applies to one property. I have seen situations where each spouse, they were married, but each of them claimed successfully a homestead exemption on each of their properties. That is a very unique situation, but I have seen. Bless you.
Now, what can we do to shorten the time span of going through this probate process and get that listing when we know someone close that's ready to go, but the courts haven't finished it, or maybe prior to somebody passing, but just about to passing?
I would say engaging a probate attorney early on in the transaction is the best way to shorten the time period. Getting an attorney involved early is really the only way to get the ball rolling and getting the necessary time periods depending on which type of probate is needed for closing. So when you get a title commitment, or even earlier, if you know that person on title has died, telling the family or heirs or other joint owner that probate is needed and getting an attorney on board early is the best way to shorten the transaction period. Unfortunately, in certain types of probate, there are required timeframes like creditor claim periods and the like that can prolong a probate. Unfortunately, you hear nightmare stories about probate taking months and months and months. If you get a competent attorney in early, we can deal with those issues early on and get the real estate transaction closed sooner rather than later.
And again, if it's a homestead property, it's not going to be in probate. So that'll typically happen quicker. If there's an attorney involved, that's just filing a petition. The court determines that it was a homestead property, and then that's out of the probate. So you actually don't have to wait for the probate, to finish to begin that process. But what's important about that, and again, knowing who you're dealing with and who's going to have authority, is that don't assume that because somebody died, it's going to be the personal representative, because if it's homestead property, it's not. The personal representative won't have any authority over that property. That's going to be the lineal descendants, the children. There may be many, and they may disagree. So that's a situation you see a lot. Hopefully not in your cases, but it's going to be the children that you'd be dealing with, not the personal representative, if it's homestead.
So if there's a property that's homestead and person passes away and we sign a listing agreement with their only heir, let's just say a son, early, does that invalidate that listing agreement until the probate process finishes? Where do we need to watch out with our dates?
Well,
So he mentioned it earlier. Title for homestead property vests when the person dies. So they would have the authority to sign a listing agreement. It's just before you can close, you'll have to have an order signed by the court saying it was the person's homestead. Think of it as backdating it to the person's date of death. It's just the document that evidences it for title purposes is that order signed by the probate judge. So to answer your question, if the only heir signs it, it does not invalidate the agreement.
So. By person to list a property, person who passed away. We need to ask, is this a homestead? Was this their primary residence? Was this a homestead property? Because from what I understand, you're saying that that personal representative may have zero authority actually to list and sell the property. It would be the lineal descendants.
Okay, you ready for the answer?
Sure.
Because if the decedent devised that property in the will, that can destroy the homestead exemption. So, which case it's subject to creditors' claims, but. Right, so if they gave the property to their neighbor, then it's not going to the children. It's going to be a probate asset. The personal representative has authority over it, and it's going to be subject to creditor claims. It loses the homestead exemption.
So when he said lineal descendants, spouses and minor children cannot be disinherited, meaning if I have a will and I leave it to Matt, but I'm married or I have a minor child, that devise to Matt is invalid under Florida law. I cannot disinherit my spouse or my minor child. A spouse, though, you can have a prenuptial or postnuptial agreement. That's different. But in some contexts, when you have minor children involved, a will might not have any authority over that property because Florida law steps in and says you cannot disinherit your minor children.
You can disinherit adult children.
Yeah,
Typically what you.
yeah. To answer your question, that's correct. If you don't have minor children and you don't have a spouse, you can leave your homestead to whomever you choose.
A lot of times one of them's an attorney. But it's always when I almost hang up the phone because it just turned into. So is there something about siblings? Person passes away, it was homestead, and there's two siblings, then what? Is that complicated? Does it matter if they're not children? I mean, they're adult children. Yes, adult children.
So if it's a homestead property and you're talking about parent dies, two children, siblings, right? Is that what you're saying?
It's of someone who passed. First. Sibling of the decedent. So does that complicate things? Can they disinherit that person and there is no will? What happens?
So there's a couple issues there that were in that example. So again, I'll say that the only thing that complicates the primary residence is when you have a surviving spouse or minor child. Otherwise, it doesn't make it any more difficult from a probate perspective in a real estate transaction. Now, if you have people who are inheriting property, whether that's the decedent's siblings, nieces, nephews, fortunately, human nature is sometimes they just don't all agree. And so, you know, that aspect of it might be difficult to deal with from a real estate transaction perspective, but from a probate title clearing perspective, no, it doesn't make it any more complicated. I don't know if that answered your question directly. What we can do is we could talk to you about your specific situation. Yeah.
So I think realtors want to know, how do we get these leads? Where do we go? What's the first step when somebody passes? What's a weekly or daily thing that they can do? Where do we get the info that somebody has passed? And then we can go start doing our searches of descendants and so on. Is this public information?
I mean, the estates are, it's in the, you want to be checking the court file for, you know, people who passed away, but beyond that, I don't know. They publish notices to creditors and usually in the Observer.
Yeah, and so I have had situations where realtors, they look at the obituaries and then they see where the person died in the county, and then they look at the property to see if it's worth their time, and then they wait to see if a probate estate is opened in that particular county. And I have seen it where I have filed in a county and the very same day a realtor has reached out to me and said, hey, if theirs want to sell the property, here's my card and let them know I'm available. So there isn't a national record that says this person died and they have probate assets and you can go look at it like an MLS. So there is a little bit of research that you would have to do for that. But there are plenty of realtors that basically shop the market for decedents and try to market their services to the estates and to the attorneys for the estates. Because he's correct, once you file it with the county, that is a public record. So you could look at the clerk of court and see a new estate that was open. And if it's a property that carries potentially high commission, you could reach out to that estate representative or attorney. I can't promise you you'll get the listing, but at least your name will be out there.
Okay, and when it comes to the probate process, how long does this process take before a home can close and actually be sold in the closing? It's one thing to take the listing and market it, but let's just say it's a cut and dry deal, nothing too complicated. How long does that process take?
Oh, nothing is cut and dry anymore. Unfortunately, the answer is it depends. It really depends on, was it the person's primary residence? Did they have a will? Had they been deceased for more than 2 years? There's a lot of factors that go into probate. And that's why it gets back to our initial point, was reaching out to an estate planning and probate attorney early on in the transaction is the best thing to do, because we'll get all of those issues addressed and you won't have to worry about it.
And, one of the things you could do, because ultimately you're not going to be hiring them. I mean, it's going to be, the family or whoever. But, if you have a relationship with a probate attorney, an estate planning attorney, that you can call up and say, hey, here's my, situation. What do you think? What do you think I should do? I think that's probably a useful thing to do, because again, don't want to waste your time. So, you run a question by and, maybe they can at least give you some guidance. They can't give you legal advice on what's going to happen, but just sort of say, might take this long, or this could be a problem, and that may help you.
And this is actually a good segue. So I don't know, a lot of you might be familiar. Berlin Patten handles a ton of real estate transactions. If you guys ever have a situation that comes up, my cards are in the back too, and I'm sure Matt's materials are out there too. Reach out. I don't charge consultation fees. So if you have a situation that comes up and you want to run it by us to see what might happen from a timing perspective, I'm happy to take 15, 20 minutes to talk to you about that. So use us as a resource. That's what we're here for outside of this panel. So feel free to reach out anytime you guys have questions. Yes.
Changes.
So this actually applies to the power of attorney, the trust, and the wills. Florida has what's called the full faith and credit clause, which says that if they were properly executed, the documents were properly executed in the state that the person was a resident of at the time that they executed them, Florida will honor those documents. However, Florida and other states have different real property laws. And so if you do move to another state, we always suggest you meet with an estate planning attorney to review them to make sure you don't need to now update them, because the laws in each state are different. I have had plenty of clients who've moved here. They just did their documents a year ago and they say everything that they want. And they come to me and they say, Matt, do I need to update these now that I'm a Florida resident? And I routinely say no. If they say what you want, these are perfectly effective here in Florida. But it is a good idea to always have an attorney look them over, just to make sure there isn't something that you have to update, because we do have those unique homestead laws that Matt was talking about. And so that's about, and one other pitch is that I don't charge a fee to review those. I only charge to draft documents. So if you guys have clients that are moving from out of state that, want somebody to look at them to make sure, I'm happy to look at them for you, and I'll make you guys look good having a local referral source to make the client peace of mind that they don't have to change them.
She's saying. This becomes their primary residence. They've got a trust. Do they not have to put that new property by in the trust for that? Does that matter or not?
And they don't have to. You can hold property out of the trust. They may want to, if they want to amend it.
So whatever, they have to amend it and put that property in the trust, right?
Right.
So the question was, if a client moves from out of state, they have a trust from another state, and they have property in another state, and they have now established residency here in Florida, do they have to put that property in their trust? The answer is no, they don't have to. But if they want it to be an asset of the trust and be subject to the terms and get the benefits of being an asset of the trust, yes, they would need to retitle that property in the trust, or when they do the initial closing, they would close in the trust, so that way it's already in there. That is certainly something that you'd want to talk with an estate planning attorney about, because there are reasons why you might not want it to be in your trust. So.
Okay, so next question has to do with avoiding probate. Is this a good idea to avoid probate? What can we do to avoid it? What are the pros and cons?
There's, I mean, I'm not going to say the line. But let's say there's different circumstances that may justify avoiding probate or not. It's, you know, I've always found that probate isn't something that you have to be terribly afraid of. I mean, it can be an efficient process. It's got some really favorable creditor notice procedures in it. In fact, I've seen situations where somebody creates a trust, puts everything in the trust, and then sets aside a little bit not in the trust just to get the benefit of the creditor notice procedures, which can limit creditors to 90 days to make a claim. You know, so it depends. It really, it has to do, I mean, some of the assets that you're dealing with might warrant a trust or not warrant a trust. There's a lot of different considerations that would go into something like that. I would say that, you know, if you had particular questions on it, you'd want to contact an attorney, let them know what your situation is, and they can let you know whether or not a trust is really necessary.
And there are a couple of mechanisms to avoid probate without a trust. You know, ultimately, a successful estate plan should probably avoid probate, but there are other considerations to, you know, some assets might have to go through probate. But I mentioned a ladybird deed. That is a way to avoid probate on real property, and it's not limited to your primary residence. You can do things like beneficiary designations on financial accounts, retirement accounts, life insurance. Beneficiary designations do not go through probate. They pass directly to the beneficiary. A trust is just another vehicle to do that. And the good thing about a trust is it provides you with flexibility, number one. Two, it covers a lot of the what ifs. So if I put my spouse as a beneficiary on my retirement accounts, but she passes away before me, if I don't go and change that, then I'm going to have to, my family would go through probate to deal with that particular asset. So having a trust, you can cover the contingencies of what happens if this person passes, what happens if this person passes. If you have minor children that are involved or somebody who suffers from an addiction or a disability, trust just gives you that flexibility that some of the more simple estate planning techniques don't. You know, everybody doesn't need a trust, but it's just another vehicle that allows you to avoid probate, which you can successfully do without a trust. There are a lot of options out there, and that's why you need an estate planning attorney to help you. I don't think that LegalZoom covers a lot of these considerations because you just don't know. Well, I guess you don't know what you don't know until you talk with an attorney about it.
So you mentioned that, you know, a trust gives you flexibility where you can amend it, change it, and keep revising it. On a ladybird deed, is that the same case? If you make a ladybird deed, let's just say you're not married, but you want your partner to get that homesteaded property that you owned, you file a ladybird deed, you register in the clerk of the courts, from what I understand. Can you undo that? Does it give you flexibility?
It depends. So there are two types of ladybird deeds here in Florida. There's a regular life estate, and there's what's called an enhanced life estate. If drafted properly, an enhanced life estate allows the life tenant, so the person, call it the principal, to change that at any point in time. They can mortgage the property, they can sell the property without the sign off of the remainderment, those beneficiaries at the end. Some attorneys, and there are reasons why you wouldn't make it an enhanced life estate deed, just a regular life estate deed. You would require the beneficiaries to sign off on a sale or mortgage or anything like that. So if it's an enhanced life estate deed, to answer your question directly, you can change it without anybody else's permission. If it doesn't have that enhanced language on there, it does require the remainder interest to consent to a change in the deed. So that's a very important consideration, but there are some reasons why you might not want an enhanced life estate deed versus an enhanced life estate deed.
What about taxes? What can we talk about taxes in terms of the probate process?
Well, I mean, so there's, if it's, okay, well, I guess the good place to start on that is step-up basis. Because this seems to be, I've had questions on this that some people seem to be confused about it, but if, I guess take one of our examples, somebody dies, their children inherit the property, you know, are they going to have to pay taxes on the capital gain from when the deceased parent purchased it? And the answer is no. They get a step-up basis to the date of death, which is really great. That applies to other assets as well. But their gain would only be from the date of death. So, somebody bought a property in, 1980 for $15,000 or something, and it's worth $500,000 now. And it was worth $500,000 the day they died, and they sell it for $515,000. The gain is $15,000. It's not the 500 and so. I think that's a good place to start on taxes.
Yeah, so when somebody dies, I usually suggest that the beneficiaries get an appraisal on real property. You're not required to, but what that does is that gives you a tax basis. And the IRS rules say that if you sell inherited property within a reasonable amount of time, the IRS does not define what reasonable is, but in my experience, it's anywhere between 6 to 8 months from inheriting the property. The IRS says you sold it for generally what you got it for. And so there wouldn't be any capital gains. So when somebody dies and they come to me and they say, Matt, what are my options here? I tell them, if your intention is to sell it, it is much better to sell it sooner rather than later because of that reasonable time rule under the IRS. If you hold on to the property, and again, they don't define what the timing is, but I'd say anything over a year, you may have some capital gains because you didn't necessarily sell it for what you got it for. There might be some market increase from the year of the person's date of death. But having that appraisal there gives you that accurate basis. And appraisers can do retroactive appraisals back to date of death value all the time. Is it required? No, but I think it's a very good benefit. Yes. The IRS rules require a qualified appraisal. If you were going to file a tax return to reflect the gain or loss, they would want to see a qualified appraiser with a license to attach to the return. Her question was, do we need to get an appraisal or can we kind of do our own report? And my advice would be to get a qualified appraisal done.
And so let me jump in on that. Now, so when you go to make your estate plans, and like Matt was saying, you got to talk to an attorney and make sure that you're doing what's right. Because one thing I've seen or people have asked about is, well, I'm going to avoid probate. I'm going to add my son to my deed. I'm just going to make him joint tenants with right of survivorship now before I die, and that's going to avoid the probate process. Well, you just transferred half your basis to your child. So they don't get the benefit on one half of that property. They're not going to get the benefit of that step up basis because that's a gift. So when you make a gift, the basis transfers. When it's devised after death, the basis steps up to the date of death valuation. So be careful. Make sure you're talking to an attorney that you're doing something that's ultimately going to benefit you and beneficiaries.
And to piggyback off that example, when you do add somebody to title while you're still alive, like you said, you are making a gift. As the person making the gift, you could potentially be subject to federal gift tax as the person making the gift, not the person receiving the gift. Right now, under the current federal tax law, you can gift up to $18,000 of value per person per year. And so if I were to add Matt to the title of my house, my property, half of the property would be a gift. Anything over that $18,000 value, I would be subject to the federal gift tax. Now, I'm not going to, you guys probably haven't had all of your afternoon coffee yet, so I'm not going to bore you with what that looks like, but you might not have to pay the tax, but you could potentially be subject to it. So before you ever add somebody to title, talking to an attorney about the consequences, not only from a probate avoidance perspective, but from a tax perspective, and we're talking about things other than income taxes here, it's always a good idea to make sure you understand the consequences of the actions that you're doing when it comes to gifting property.
So is going back to the stepped up basis, I heard that when investors do 1031 exchanges over and over and over their entire life, that eventually the heirs get the stepped up basis, right? You might have a very, very low basis because of your 15 1031s over your 60 years of life. And then they get, basically they have very low taxes upon selling all those assets. Is that first of all, is that correct? Or is it, does it depend?
1031 exchanges is not part of my practice, and I am not going to venture into making any kind of legal recommendation on that. I don't know if Matt's.
Yeah.
That, but go ahead.
A couple of times. So the premise behind a 1031 exchange is you're effectively deferring the capital gains tax. If you sell an investment property, you cannot, it doesn't qualify for primary residences. If you sell an investment property and you buy a like-kind property with those proceeds, you can effectively defer the capital gains. And in theory, you can do that again and again and again. And what that's, and we're talking about individual income tax here. So if you then die with property that is subject to that 1031 exchange and your beneficiaries ultimately inherit it from that stepped up basis, put in plain English, the capital gains gets wiped out. And your beneficiaries aren't responsible for floating the tax bill on that because of that stepped up basis rule. Now, unfortunately, especially in taxes, the answer is sometimes it depends, because if the estate were to sell the property, it could potentially be subject to the estate tax versus as if the beneficiary inherits it and then sells it. So there are some situations where you can only kick the can down the road as far as the taxes go. But I have seen it where the taxes were deferred all the way through the client's lifetime. They passed away and the capital gains were wiped out. So her question was, if a person inherits through a ladybird deed or a trust, do you get a stepped up basis? For a ladybird deed, the answer is yes. For a trust, the answer is yes if it's a revocable trust. If you inherit assets under an irrevocable trust, you do not get the stepped up basis. Unfortunately, I guess I will have to get a little bit more dense in the tax law. So the reason why beneficiaries get a stepped up basis is because the asset was included in the decedent's taxable estate. And in a revocable trust, all assets in a revocable trust are included in your taxable estate. When we do complex estate planning, and this truthfully is for more higher net worth clients, especially with the current estate tax exemption, we sometimes create irrevocable trusts, which are the ones you can't change once you set them up. Assets that are properly put in an irrevocable trust are not in the decedent's taxable estate. And because of that, the beneficiaries do not get a stepped up basis in an irrevocable trust. I would say 9 times out of 10, you're dealing with a probably more, 99 times out of 100, you're dealing with a revocable trust. That's correct.
So we have about 21 minutes left to answer or dive into something that we didn't address. Does anyone have any questions or any thoughts, maybe some we addressed? Yes?
Steps documents set up. Set up.
Grab one of our business cards and we can set up a consultation. I will reiterate that I don't charge a consultation fee. So I'm happy to sit with you down in person, phone call, Zoom, talk about your specific goals and needs. And then I would give you a fee quote at the end of that. And if you decide to go in a different direction, I don't stick you with the bill for the time. Yep.
Well, what I'll ask is, as realtors, let's put on the hat of a realtor. What should, talking about everything we've talked about, let's summarize the most important steps for us. Documents. How deep should we go on getting documents?
I think if you take a step back, look, we covered a lot of topics here, and some of them are quite dense, and you heard it depends a lot, because these issues can be really fact intensive. And it's all dependent upon that particular situation. So it's really hard, in an hour and a half to kind of explain all this to you in a way that leaves you, where you walk out and say, I understand all of it. It's going to change, and it's going to be fact intensive and dependent. So the really important issues, I would say, is number one, make sure that you're dealing with the person or entity that you need to be dealing with. Make sure that the person who you're contracting with has authority to do that. You can do that by, kind of just taking the first step into document verification. You don't need to sit down, analyze all these things, totally understand it. You don't need to have them reviewed by attorneys, but, if you're dealing with the trust, you can ask, that they show you the trust document or the certification of trust. If you're dealing with, power of attorney, you can ask to see a copy of that. Just make sure that you're dealing with who you're supposed to be dealing with on that.
I'd say if there's one thing you go to look at in any real estate transaction, it's the prior deed. That's the first thing you should always go to. Don't rely on the property appraiser. Unfortunately, don't even rely on the person telling you that they can sell the property. When you get the property address, I would go in. It's very easy to click the most recent deed on pretty much every county's property appraiser website. Just look at the prior deed. There unfortunately is also sometimes when even the deed is incorrect, but for the most part, that's the best way for you to look to see who you need to be dealing with. And then you can kind of, your wheels can start turning on. Am I in a power of attorney situation? Am I in an LLC situation, a trust situation, a probate situation? And you'll be better equipped because you know on the front end who you're most likely dealing with. And I think that prior deed is your best starting point for that.
And are there any differences when dealing with commercial real estate or residential real estate?
From everything we've talked about here today, the answer is no. The type of real estate that you're dealing with, whether it's vacant land, residential, duplex, commercial property, the answer is no. Some properties have special uses that, if they have easements and things like that, you're going to find that on later and on in the transaction. But with the ultimate question I think we want you guys to take away from this is who are you dealing with as the realtor? And looking at the most recent deed, regardless of what type of property that is going to help you. One other clarifying thing that we do here have land trusts in Florida, and a lot of clients, especially high net worth clients, create a land trust for privacy purposes. Even in a land trust, the public records reflect who the trustee is of a land trust. So you might not know who the ultimate owner of it is when it comes to who owns the land trust, but the trustee will be listed on there. So if you see a land trust, don't be scared away from that. It is treated no differently than a revocable trust as far as authority goes. The trustee is the person who's in charge of that. So.
Like Saturday, someone has a set of property that's destroyed in the storm. Gonna put it on the market. There's currently a home on it. It was homesteaded. It's gonna be sold really as vacant land because the home is not usable. Is there anything in there that's gonna be a problem for any reason?
Is the person still alive?
For purposes of what we're discussing today, no, I mean, it's just it's an asset. I mean, frankly, regardless of the condition of it, it's an asset. You're making sure you're dealing with who owns the asset and that they have authority to sell it. That's it.
Yeah, and the question there was about homesteaded property that got destroyed by natural disaster, now being sold as vacant land. So that homestead still stays in effect, and the benefits of the homestead stays in effect, is what it sounds like.
My only other caution is if they have an open insurance claim or they're starting an insurance claim on that, you might need to be aware that that could delay things potentially. So if they are just selling it as is and getting out of Dodge, so to speak, without going through insurance or anything, then you should not have any, not going to have any issues there. But when you open an insurance claim, that is something that can potentially cause issues with title.
All the insurance stuff is done before you can list.
It depends.
It's just it could complicate it.
Yep.
Well, from what I know about that question, which was if there's an open insurance claim and when do we list, when is it too early to list? From what I know is that insurance won't be bound to the next buyer if there is an open insurance claim within the insurance clue system, which is like a back-end system we don't have access to, but insurance agents do. However, there's always those, those cash buyers, we buy houses cash out there, those wholesalers that will take possession with that kind of blemish. Is there anything else you have to add on that topic?
I think you covered it, actually. I think that's a good point.
So you can sell it, but it depends. But okay, excellent. And
well, if you're representing the seller, that would be one of the questions that I ask the seller. Oh, I actually don't think I don't think there's a database that.
Said they have the ability, the insurers have the ability to do some back-end system, but we don't have any ability to do that.
yeah, so real quick, the question was, how do we as realtors check if there's an active insurance claim? And there is no, from what I know, only my insurance agent right before binding it goes through that process, checks all the insurance agents to see if there's an active claim, and then he kicks back. I just had this recently, kicks back and says, oh, sorry, we can't do anything until that old claim is closed, and that caused a 3-week delay for my seller. Yes.
So you sell for a year. 5 days or some damage of some kind. Even Debbie somehow got water into my house. I don't know how in Lakewood Ranch, but, so I got a claim for a year. And I just got a new roof put on, and I'm still waiting for money for everything, all of my damages, so it's been 1 year. So those of you that are working with people that had damage to their roofs, I already have, I can tell you, I have 3 clients in the last 2 days that called me and thought they could sell their property, whatever, and we're dealing with this immediately. So this is very pertinent, and they think they can sell their home right away. And if there's damage, you know, depends on the amount of damage and who can buy it and the repair. So that's really important for you to say, don't open that claim. If your home is really beyond repair, don't call the insurance agent, call a couple of realtors and attorneys and get good advice before you do that. Because my home has been tied up for a year. I couldn't do anything except live in it.
And what we unfortunately are going to see in the next few years is people who are doing things unpermitted to repair from damage and things like that, which will eventually cause title issues when they go to sell down the road. So right now, it's probably not going to be an issue, but as people start getting older and maybe wanting to upgrade, downsize, whatever the case may be, always be on the lookout after a couple of storms that people doing unpermitted work, which can cause title issues.
Yeah, and I guess just to tie that question back to the panel here, which is about probate, in a situation of probate where there are active insurance claims, have you seen that? We might be seeing that, right? With 3 storms within 2 months that we've had. What does that look like?
Yeah. Probate and, you know, there's an insurance claim going on, the personal representative is going to be the one handling that. 'Cause again, they're the one acting on behalf of the estate. You know, from a real estate perspective, it would just be the same complications as an individual. It really wouldn't, you know, it doesn't change it because again, the estate is acting as an entity, it's acting as a person. So from your perspective, it's not going to change. It's not going to be more or less complicated. It's going to be equally complicated between each of them.
I've had estates carry on simply to wait for the resolution of an insurance claim. You know, we got everything else administered, so it can take some time. And as you all are probably well aware, insurance here in Florida is not ideal to deal with. So,
All right, excellent. Any other last questions? All right, well, thank you very much, guys. Thank you, Matt. Thank you, Matthew. And we'll be sticking around for a short bit. If you guys have any questions, come on up. Thank you.
yep.
Take a couple of videos with me. I have like a YouTube channel about it's called Florida State Security. Yeah. I show them the damage, I show them the types of stuff. So they do. Yeah. Yeah.
You got my,
Yeah.
you have my cell phone? My cell number. Yeah. Okay. There you go. Yeah. So. Okay. Yeah. Oh, great. So I've talked to, like I said, I practiced law for a long time, but I work with, okay, but yeah. Oh, okay, no problem. Yeah, I'm not counsel, a law firm, but, so if you want to give me a call, something, if you have questions, I can talk to them and see what they would take. That's my role. Yeah, but, yeah, yeah. Thank you. Yes. Okay, I have this card, and then they probably want the law. But I have two roles. Sure. Yeah, that's fine. Where are you putting it on the Zoom? Legal questions? Can I write it down for you? Yeah. They're probably going to be looking for the law firm. Yeah. No. Yeah.